Welcome back, Mr. Ebun Adegboruwa joins us now. He's a legal practitioner. Thank you for coming on this morning.
Thank you. Good morning.
Well, you're listening to both parties in terms of what is going on, but in terms of the legality of this matter, or maybe let's get your general opinion first. What do you think about what's going on?
Well, two sides of the coin. First is that the people of Ekiti have indicated by the votes they gave out on whom their preference is as to the choice of governor. That's one side of the coin. The other side of the coin is that there is a judicial process that has been initiated by certain aggrieved or people who are not satisfied or happy with that outcome. That process should be allowed to go ahead. I look at Ekiti State generally, and just looking at the fact that the people deserve the kind of leadership that they want. I don't know who Fayose. I'm not too conversant with his personality, but no matter who he is and what he has represented in the past, if the people in spite of that have willingly surrendered their vote to choose him, we must allow that choice. However, if there are opportunities for people to challenge that choice, that opportunity must be respected. In other words, you don't, out of perception, out of fear that the judgment may go this way or that there's likelihood of bias, disrupt the process of judicial intervention. Because that likelihood itself is accommodated by the judiciary. I have filed an objection before a judge and said, I suspect that given so and so facts, you are not qualified, with all respect, to sit on this matter. I filed the application before the judge in the matter that I'm handling. And the judge read it and said, I don't need to listen. Judgment is all about confidence. If your client does not have confidence in my ability, I on my own self will disqualify myself. He called me and said, Mr. Adegboruwa, you don't need to argue this application. If your client does not feel secure in my court or does not have confidence in my ability to preside over this matter objectively, no matter the reasons you have given, I would like to disqualify myself. So there is no reason, no basis whatsoever for anybody to storm a court, to stop a judge from sitting, even if you've caught that judge taking bribe. All you needed to do was to take the evidence of that bribe to either that judge or to another authority, because the judiciary is so vast in terms of the opportunities created. Because the scenario is this: if, for instance, now those who are in the High Court feel aggrieved that Fayose or people of that group have gone to the Court of Appeal to appeal against the ruling on jurisdiction, and they have filed a motion for stay of proceedings. If the other side feels in their heart the way the other side are feeling, that the Court of Appeal will not rule in their favor, so all they needed to do now is to also mobilize thugs to storm the Court of Appeal to stop it from proceeding on their own case. Because and that will spell doom for us in judiciary. So it's neither supporting Fayose or supporting E11. Our own is to say that you must allow a court under the Constitution to determine dispute between parties, between governments, between companies, between individuals. After that decision, if you are aggrieved, there are several avenues.
Okay, let's pick up on that.
Let's take it, Chairman, let's take it from the perspective that the people felt that this was their mandate being threatened, and so they decided to invade the court. Are we worried about the perception of the judiciary in that light? You know, the perception that the judiciary is where you go if your mandate wasn't given to you freely by the people.
Well, honestly, I will go by Section 6 of the Constitution, which we all agree to as a people, to say it's better for us that dispute be resolved in a transparent manner. The law of the jungle, the law of the mind, the law of self, the law of the might may not be in your favor, may not be in my favor. And that's why we created the courts under the Constitution. Section 6 creates judiciary and says clearly that every court will have power to determine disputes between individuals and between governments. So no matter that dispute, it can be a dispute as to election petition, it can be a dispute as to governorship, it can be a dispute as to commercial business, it can be a dispute as to marriage, it can be a dispute as to paternity, it can be any dispute at all.
Do you think the people are accepting that? That is definitely a question. If we say that, if we take it from the E11 says it was the people, the supporters of Governor Fayose. Governor Fayose's people say, no, these are Ekiti people who are trying to protect their mandate. Should we be worried that, or should we ask if the people are accepting that that's the role of the courts in this particular situation, and they should have waited for the courts to come out?
I will appeal to the people of Ekiti to accept that the court should be the final avenue for ventilating grievances, because the other alternative is unpalatable.
Has it always been like this?
Well, it's unfortunate, especially for the Ekiti scenario. If you watch the events over time, the intervention of judiciary will seem to have given the impression that the votes of the people does not count, and that's unfortunate, because in most cases, when these votes have taken place and winners have been declared, the outcome of those elections have been annulled by the courts, in many cases, especially in Ekiti. So maybe that's what has led them to this conclusion, that there is this attempt again to steal the mandate, so-called, as it is. And that mandate is being challenged in the tribunal. And I listened to Mr. General when he was here, and a point that I like to make is this. And it's unfortunate that that comment came from him. If you say the population of Ekiti is about 6 million, both at home and in diaspora, and you do not accept that the votes of just 300,000 people should constitute a mandate for deciding the winner, how will 56 people? I mean, I just was reasoning with his own logic when he was analyzing. If 300,000 people cannot decide a governor, how will 56 people decide it? In terms of 56 people sitting down to continue to say we do not accept. And if that was their view prior to the election, once the election has been conducted and you congratulated the winner, it stands on logic that you have to go and withdraw your case. Because the case was pending before the election. This issue of integrity, this issue of indictment were all existing before the governor was elected. And if you knew you wanted to pursue that, then you stay clear of either congratulating or disagreeing with him, since that's a political matter, which is already in the tribunal between PDP and APC. And the E11 is not involved in that, since they are not politicians. But for you to have joined fray, to say we congratulated him, and you asked him and he said the reason was because we wanted peace to prevail, which means you are taking people for granted. The governor himself, Fayemi, congratulated Fayose only for him to renege to say they wanted to avoid violence. You don't play people by pranks. If you don't accept the election on principle, you don't accept it. But once you have accepted it and you sign a statement congratulating and say a winner has emerged, let the state move forward, then you stand by that declaration and ensure that you avoid things that will create tension. And I thought that it stood to reason to say once you have congratulated the winner, you must live by that congratulation by your conduct. But if they insist on going ahead with the case, we cannot force them. We cannot beat them. We cannot kill them. And aside from E11, APC, and PDP, the option of those who fear that judgment may not go in their favor, taking the law into their hands, spells doom for all of us. It's not just in Ekiti.
Because we cannot afford that.
No, even look at the scenario. It's very clear. An armed robber who's been arrested and caught with crime or killed somebody to collect his money or collect his car is facing trial. Members of his group who do not accept that trial should go on will come there and kidnap the judge and beat him up. And then they'll go back and be clearing all the policemen that are to be listed as their witnesses. Boko Haram members who are arrested and detained and being prosecuted, who do not want that trial to go on, we go to the court and invade there and kill all the judges.
So how can we stop this bad precedent?
I mean, there's no justification whatsoever, either on the side of E11, on the side of PDP, on the side of APC. Whoever is responsible for that action must be brought to book. We cannot keep it under the carpet. And this is a responsibility for the police. Because the Constitution gives the police the power under Section 215 and 214 to be able to take responsibility to maintain law and order. There is no way we will accept any excuse to say we cannot get the scapegoats, the people who invaded the court. We must get all of them, and they must be tried. If they are found guilty, they must serve the sentence. It must serve as a deterrent. All lovers of peace in Nigeria whether as lawyers, whether as businessmen, whether as politicians, must not allow this to go on at all.
Should we?